All right, Victoria, you ready?
Yes, Judge.
All right, let's roll. Words.
First, we have page 16, Salto. Come on.
Hey guys, do you mind helping me out so we can just do a couple of arraignments? This is Salto.
Yes, Your Honor. Yes, sir.
You are Francisco Salto.
Yes, sir.
Mr. Salto, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On December 20th, 2022, officers responded to the theft call. The complainant stated she was inside Eagle Hall, a bar in Harris County, Texas, when she noticed someone had stolen her purse with approximately $130. The complainant pointed out a male who was sitting next to her when the money was taken. The defendant later admitted the offense to the officer and that he took approximately $140 from the complainant's purse.
How did they see who saw him?
There was no allegation that he was necessarily seen taking the money. From what I understand, Your Honor, the planning witness was sitting next to the defendant. She noticed the money was missing. Officers arrived, asked the defendant about it, and the defendant admitted to taking the money.
Got it. Okay. Mr. Salto, I'm going to find that there's sufficient probable cause to go forward with the case. I am ordering you now as a condition of your bond not to go back to this bar. Do you understand?
Yes, sir.
You're also ordered not to have any contact with the complaining witness in this case. If I find that you pick up a new case, if I find that you violate any of these conditions, I will lock you up and I'm going to make your bond extremely high. Do you understand?
Yes, sir.
I guess, I'm going to order you not to go to any bar. You're ordered not to go to any bar. You understand? You have the ability to hire a lawyer, sir. Do you have the ability to hire a lawyer?
No, sir.
Okay, I'll have you fill out an application. We'll look to see whether you qualify for a court-appointed lawyer. For a court-appointed lawyer, I need to know everything about you, whether you work, how much money you make a month, how much money you have in the bank, what kind of car you drive, and then we'll look to see whether you qualify. Deputy Etchigoin is going to give you one. We'll have you sign a receipt, and then I'm going to have you take a seat in the jury box. Do not leave until you sign the bond conditions, sir.
Go ahead and sign, please.
So, no going to any bar.
Yes, Your Honor.
No going to this one, especially. No contact with the complaining witness, no new cases.
Judge, that's the only one for now. The other one has an attorney that's not here yet.
What's the last name?
Gonzalez. On page 7.
Got it. Any THAs?
No, Judge.
Counsel, you ready?
Yes, sir.
Come on up. Hey,
How are you today?
pretty good, you?
Just quickly wanted to do a motion to substitute
Okay.
on a case and I have it there for you.
I'll put it in here so I'm trying.
Got it. Very good. Is it on docket today?
Miguel Castillo is on the docket today, Your Honor.
Senator Lopez, Judge, on page 12.
Is it an old case, Dave?
Brand new.
Got it. Okay. I don't have it yet, but I'll sign it when I get it and then you guys are good to go.
Your Honor, I'm Attorney Reese from Pearland and this is my law clerk. He
Nice to meet you.
just took the bar and graduated law school.
Nice. Congratulations. Treat it well. It'll treat you even better. I swear. This is such a great profession. You'll learn like crazy and then the sky's the limit, man. If you treat it well, it'll pay back tenfold. Really.
We're excited to join them.
Yeah.
Thank you, Your
Okay,
Honor.
guys. For sure. Take care.
Judge, can I give you a call today?
Yeah.
It's, when you're ready.
I'm ready.
2535
Okay.
924 for Great House. So I see on Friday that he signed a no driving affidavit and then an amended order was made from the pretrial officer in here that day.
for Scram. So I'm assuming in the amended order, you also wanted no driving.
Correct.
So I will have to make an amended order on that.
Yeah,
Because
just
it
waive
wasn't
it.
there. However, the case manager reached out to me and said that he believes the client was driving yesterday because his ignition interlock, reported him driving and there was a roll and retest. So leading him to believe he was doing that. But we will not be able to submit a bond violation due to that box for no driving in our conditions, pretrial conditions.
I
being
ordered him on
selected.
that day, not to
Yes.
drive.
Yes, and
So
so
he
they're
knew
not
not to
driving.
drive.
Yes, he knows not to drive, because of the no driving affidavit, but that's why they reached out, because they said, hey,
So
And
can
our
you get
conditions are
pictures
okay.
of him starting the car?
I can get the report.
Right, I want you to file a BVR.
You'd like to file.
Yes,
okay.
file a BVR.
Let me
And I'm gonna
reach
set
out.
it, and then we're gonna provide pictures to council, and then we'll have a hearing on it.
Yes,
on
Judge.
Monday.
Today as well, Judge.
Driving today?
Yes, Judge.
Okay, I'm ready.
Yeah, if you can file the BVR today, please.
Yes.
What is this?
Hi, coming up. Good morning.
Nabiyama, it's an off docket matter. The cause number is 254-3073.
Okay.
Okay,
I wanted to approach about his bond conditions. He was ordered to get an interlock device. However, he was incarcerated from January up until, last week. But while he was incarcerated, his brother actually wrecked his car, so he no longer has the car, so he's not driving. His license is also suspended, so we wanted to see if we could get it, changed over to a portable.
okay, but I need him here to sign an affidavit.
He's
Be
here.
here?
Yes, sir.
Okay, so we'll need him to sign an affidavit. Come up. Good morning, Mr. Nabiyama. I am ordering you not to drive. Do not drive. I don't care what is going on in your life. I don't care what you need to do. I don't care if you have to go to the hospital. If you do not have a license, if you do not have insurance in your name, and especially an interlock in your car, you're not allowed to drive. It's really gonna go poorly for you if you do. Do you understand? I'm gonna have you sign an affidavit with me today promising you're not gonna drive. This is a court order, so if you do, and I find that you do, I can have a contempt hearing. Do you understand? Okay, so we'll have you sign it, and then now what we'll do is we'll give you a portable device that you're gonna take with you wherever you go. I'm gonna pay for it so that there are no issues, okay? Okay, thanks, guys.
Thank you.
Okay. Here. Hey, I'm leaving here. I'm at funeral. I can go all the way down if we come to. Okay, cool. You moved before? Yeah, I got plenty of charges down there. Let me get it done. Do you want, so the felony case is the day before. You want to put them both on the same day so he doesn't have to come
Yes, sir.
2 days in a row? It's silly.
And then that's what they said.
Right now, the felony is set for 4/23 and we're set for 4/24. So it's probably just set them both for, I guess, probably the 4/23 so that way you don't have to go upstairs. Okay. Hi,
Morning, Mayor French.
please.
Approaching off docket on Mr. Escamilla. I sent an email last night on that one. Do you need a clause number?
Oh, I got it right.
Okay.
Do you need the cause number?
I do, Your Honor.
It's 239-0060.
Sorry, I didn't even think about offering it to you. My apologies.
Thank you, Your Honor.
Sure. So we're here because they filed a bond violation report. He was ordered to submit to a drug and alcohol test. He tested positive for marijuana.
Yes, Judge, that was on the 14th. He appeared in court on the 14th. That's the day I got appointed. You sent him for a drug test that day. According to my notes, he came back positive that day. He and I approached you, and on my notes from the 14th, it says he did test positive, but you were gonna give him 50 days to get clean. So I got a test date for him for May 6th, but my next appearance date is sometime in April for him, and I think he has to be here then too.
Okay.
So, but he's set for the 4th. Can we withdraw that setting and just keep how it was, please?
For sure.
Thank you so much. It's just a record snafu. Thank you so much, Judge. May I be excused? That's all I had today. Thank you.
Mr. Simmons.
Hello? Hello?
Yes.
I'm ready.
Who are you here on? Okay. I'm ready when you are.
All right, Judge, next is page 3. Davis, come on up. Danielle?
Yeah. You said number 3?
Page 3. Davis.
You are Danielle Davis. Davis, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a theft call at Walmart and made contact with the loss prevention officer who had detained the defendant. The loss prevention officer stated he witnessed the defendant concealing items in a bag and then proceed to pay for several items, but not those concealed in the bag. The defendant then passed all points of sale without trying to pay for the concealed items. The total value of the concealed items was $264.78.
All right, Ms. Davis, I'm going to find that there's sufficient probable cause to go forward with the case. I'm warning you now as a condition of your bond not to go to Walmart, any Walmart for any reason. Do you understand? If I find that you do, I will revoke your bond, put you in jail. No more PR bonds, ma'am. Do you mind filing those conditions, please?
Yes, sir.
Ms. Davis, do you have the ability to hire a lawyer?
No.
I'll have you fill out an application for a court-appointed lawyer. I'll take a look to see whether you qualify. I need to know everything about you. Don't just put zeros because I'm going to send it right back to you. I need to know how much money you have in the bank, what kind of job, what kind of car, all that jazz, and then we'll take a look to see whether you qualify. Deputy Miranda's going to give you the application. I'll have you sign a reset with Victoria, and then we'll have you take a seat in the jury box, man. Yeah.
All right, page 7. Gonzalez, come on up.
Morning, Judge.
Hey, Eric, how are you, man?
Right, I don't know, but I don't want to not put nothing, you know. Yeah, I mean, I'm just gonna. I just look at things. So I say.
Okay, I'm just.
Yeah, yeah.
She just puts all that on everything?
Looking for a job, it would.
I get it. How do you eat then? You have to have money to eat. How do you eat? You got to, okay, that's good. Yeah, social security's good. That's okay. Yeah, that's fine. As long as you put down something, so we know that you have some income coming in, right? Okay. You are Ricardo Gonzalez. Mr. Gonzalez, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling 90 miles an hour in a 60-mile-an-hour zone and failed to signal a lane change. A traffic stop was initiated, and upon contact with the defendant, the law enforcement officer observed a strong odor of alcoholic beverage, slurred speech, and red bloodshot eyes. The defendant admitted to consuming 10 beers. STs were conducted at a nearby parking lot where the officer observed 6 out of 6 on the HGN, 2 out of 8 on the walk and turn, and 1 out of 4 on the one-leg stand. The defendant consented to a breath specimen in blue .16 and .158.
Mr. Gonzalez, I'm going to find that there's sufficient probable cause to go forward with your case. You look up, see, is any prior DWIs in a license, please?
I do not see any prior DWIs, Your Honor. However, I'm unable to look up his driver's license because there is a driver's license number that we have in our system. From what I have, I'm not sure if that means he does not have a driver's license.
He does not have a license at the moment.
We're not allowed to drive. I don't care what is going on in your life. I don't care that you need groceries. I don't care that there's a kitten that has to go to the hospital. You will be signing an affidavit with me today promising me you're not going to. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. I don't know what your immigration status, but if you're not in this country with permission and you go to jail and immigration finds you, they will put a detainer and you'll be stuck like Chuck in there until this case is over, and then you get shipped off to immigration. Do you understand? Part of your other bond conditions are that you're not to consume alcohol or illegal drugs or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, you will go to jail. No more PR bonds for you. Now, you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Benavides, and he will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games and you're not responding to phone calls or text messages, likewise, I will issue a warrant for your arrest. For now, we'll have you come up here, swear a test that you're not going to drive. You'll get to Victoria to sign a reset with Fleischer for your bond conditions, and then you're free to go. Thanks, sir.
How it works, we testify intoxicated guys.
Yeah, okay.
And then
All right, I'm gonna
you just got another time.
Okay, I gotta run.
Okay.
So we're not late.
There's so much information that's been noted for alcohol, random benefits.
Guys, I got to run. I'll see you guys tomorrow, though. We'll be bright and early. Back at it tomorrow.
We are here to address the BVR. On March 19th, he tested positive for THC.
Okay, hold on one second. I didn't hear the name. What's the name?
Jose Borrego.
Come on up. He's over in the. I'm working with someone else's computer, so bear with me. What is your last name, sir? Borrego starts with a B. How do you spell your last name?
BORR.
Oh, here we go. No. Oh, it defaults to my docket. I have to go. Yeah, I got it. Now I just want to see what's in the notes and stuff. Okay. So we're here for the bond violation.
Yes, he tested positive for THC March 19th or 18th. The judge told him to return on today's date to retest. He did take the test. It came back negative for drugs. So I'm just asking that I'm sorry? He did take the test.
I was informed that he had a child present with him and could not take the test.
Yes, somebody came and got the child and he did take the test.
Let me look into this one.
Okay.
Okay, yes, my apologies. I do see that as negative.
Okay,
Okay, I was just asked the court to not revoke his bond, and we will also like to set a trial date.
okay. Well, I'm gonna leave his bond in place.
Thank you, Judge.
And I'm not gonna give a trial date. You get it from Victoria? Okay, so Victoria will give you a trial date, okay? So,
Okay, Victoria, would you like me to email you?
Yes, Ariel.
I know
Thank
you
you.
gotta go, Ariel, so,
Thank
and make
you.
sure you communicate with your attorney. She will give you your trial date. I'm gonna leave your bond in place. But I presume he needs to be tested again in a few weeks, okay?
Yes.
Correct.
Thank you.
Thank you, Judge.
Thank you. You can go ahead and have a seat.
You could have.
Okay, anybody else? Hey, Greg, how are you?
Good, how are you? Just quick, I'm on the fugitive docket today and we have a client that's just signed his extradition waiver, so I was needing that signed.
Okay,
And the reset's gonna be the 18th,
No, it's actually going to be 21st because the 18th is a
Friday.
holiday.
Oh my God.
it's been putting stuff, Trey, is that one in judges? Oh, it's paper, I'm sorry.
Yeah.
Okay. So I just need to sign.
Yes, if you could, please.
I absolutely will.
Thank you, Your Honor.
Thank you.
Or else he's gonna be there
Yeah, no,
even longer. Thank you, Judge.
Thank you.
Thank you.
All right, that's all I got. All right.
Okay. You know what? I can go ahead and. Okay. Thank you. Is that what it's called, waiver?
All right, so.
I think you did. You sent me the. I have four scores. Yes. Center text.
Okay, is that everything? Put everything in my queue. Okay. I know, thank you. Okay, I think I did all the pleas. Anybody else need anything else, Victoria? And thank you, guys. Need anything? You need anything else? Thank you.
Frederick has to approach on his client that's not here.
Okay,
Page 17.
17.
Wilson.
Mr. Wilson,
Heard the guy.
District Wilson.
I like
On
him.
Thierry
Very
Smith,
smiley.
Smiley.
Okay, I do have some answers for you. I thought he would be here, actually.
Well, except for bond forfeiture, it don't matter what answers you had.
I don't know why we were in felony court. And this morning.
He was in felony court this morning and then he left?
I told him to come down here, you know? He probably, I was moving fast, talking fast, you know I am. I'll take the blame for that.
So,
But he was actually here. And what happened, I submitted the mitigation packet. I actually submitted to the ADA on the case in here, per Judge Fleischer's instructions. They're considering it, and then we have an offer for deferred if they deny it. So basically, the end date of this case is April the 20, whenever we come back, the felony date. Because we're either gonna be granted that PTI, or we're gonna do is pleas or deferred.
on the felony.
On the felony, yes.
And or the state
This case is supposed to
go away.
go away. Yeah, because, so.
You know, this is what I have to tell you, I have to put my hat on because Judge Fleischer is tougher than I am.
You know, but usually I can talk my way out of it.
So, you know, me, you know, if the defendant did show up and he might have been confused and you saying, I thought I told him to come down
I know
here.
I told you, but you know how quickly you gotta go from point A to point B because we're
Maybe
No, he was definitely.
Victoria, what would Judge Fleischer do?
Only because it's Frederick, you would revoke.
No, he wouldn't. Me and Judge Fleischer, we're good. Let's stop talking like that. No, generally speaking, like if he's irritated.
What I hate to do to my clerks is revoke a bond and then the guy's gonna show up here tomorrow. And then you gotta go and reinstate it all.
What he wants out of this case is resolution, and that's the thing that he's been.
I get it. We always want resolution.
And the thing about, of course, I would not offer to the court a lie, because, you know, I have to deal with y'all every day, and y'all need to trust Frederick's word, right?
Let me see. I'm gonna look at the settings.
Frederick is not gonna lie to you.
Defendant failed to appear on March 20th.
Now, that day I didn't tell him he's supposed to be here. I don't know.
And I rolled it and he rolled it to set for bond for.
How about this? I'll make him come up here tomorrow, and he can check in, and then she can give me whatever. Are you gonna be here tomorrow, or just Fleischer?
No, Judge Fleischer is back here tomorrow. So look, Victoria,
Yes.
we're gonna carry it till tomorrow and let Judge Fleischer do the fussing at Mr. Smiley.
All right.
Cause
That's fine. That's it.
he was supposed to be here.
I don't know why the hell. Well, let's make sure he's in the hallway. Oh, it's pretty clear. Go check in, visit me in the court.
I don't know.
Well, if he is here, we need a status update on the mitigation packet.
He did give me one. He said that he turned it in and that they will have an answer at the next felony setting, and on the next felony setting, he's either going to be on the PTI or he's gonna plead to the deferred. We're gonna carry it over
Okay.
till tomorrow. Okay, tell him be here tomorrow and let him know Judge Fleischer is gonna put his foot up his, okay? Thank you, guys. Thank you.
Right in front of the.
You're welcome.
You ready?
Thank you, guys. I'll go back down to my court.
Thanks, Judge.
Oh, I think somebody, yeah, can you take it a while?
Thanks. Court does call the case People versus Lawrence Buckner. Who just stepped out? Pardon? Approach on this matter?
No.
On, okay. State your name.
Lawrence is a family bug.
All right, go ahead, counsel. Mr. Johnson, go ahead.
Good morning, man. Please, this honorable court, Kareem Johnson, appearing on behalf of Mr. Buckner.
All right, what are we doing on this case?
Yeah, and I have received all discovery and police reports with body camera. We're asking this matter be set for exam. However, Mr. Buckner has, I believe, 3 witnesses that I think we will want to ask the court to take testimony from at the exam. So I'm asking for some extra time to make sure I can get those witnesses subpoenaed to court.
Any objection to that? Counsel?
John, I don't object to the offer exam or to defense counsel's request. However, lead counsel is new on the case. He's not aware of something that provides the public defender up. Earlier this week, this defendant made threats to the witness at preliminary examination. And you charge,
Sir, you need to face me.
and you charge has been authorized against this defendant as a result of his conduct. And as a result of that charge being authorized, you are requesting remand. We have previously advised the public defender's office.
It's in the office.
Your Honor.
Your Honor, this is,
Sir, I will give you an opportunity to address the court, but you're not going to interrupt You're not going to interrupt anybody. You're interrupted. Yes.
This exam was held on Tuesday, and after the victim in the case had testified, Mr. Buckner, during a break in the exam, threatened her in the gallery, and we did end up charging him with threatening to injure a witness. And this is a victim that he was not supposed to have contact with, as she was a victim on the FA case. So in that sense, he had violated the bond by contacting her in court and also threatening her with criminal charges, which is why we would be asking for his bond to be revoked.
Sir, what did you want to tell me?
Sir.
Well, Mr. Buckner, I'd advise at this point, you don't make any statements.
Mr. Johnson, I need to speak because if I don't speak, if the prosecutor said they want to lock me up in remand, it's up to Judge Simpson. So I have to present my portion of the truth. If I don't, I'm going to jail. Like, I have a family to support. Please, like, I am not guilty. And this is what I,
Well,
okay, okay, on Tuesday, I had a hearing for a situation that I was allegedly accused of, right? During that hearing, it is my belief, so let me just say that, it is my belief that the coerced witness messed up the testimony. So they said that the witness said that I threatened her. I never threatened her. They said that they went to the officers, they had stuff on body cam, sir. No, it wasn't that. If you go on body cam, I was talking to my aunt Sandra Lamont and my family member, my phone was on, and I was talking to them, and nothing out of my mouth said, I'm gonna threaten that lady, I'm gonna get that lady. They have been trying to harass me and my family ever since that I got shot on Father's Day, and I didn't cooperate with the police investigation. I got shot 9 times and 1 time in the head. 2 days before all these incidents happened, please hear me out. Deputy Caruso from Washington County kept coming to my house saying, you need to testify on who shot you. You need to testify on who shot you. I said, Mr. Caruso, all I want to do is live my life. I got a family. I got my brothers here. I got people that I support. I don't want nobody getting killed. I died twice in my brother's arm. The next day, I got in an incident with my lady friend, and it went from a domestic violence to a stalking. Ypsilanti police officer Tyson came in to Washington County Jail the very night I was arrested, tried to read me a personal protection order. I said, I don't want to do it, because I didn't do anything wrong. The next day I woke up, I had stalking charge. That was dismissed. That was malicious prosecution is going on. Please hear me out. Then Jacob Dillon came to my house, tried to run me over with a vehicle. I punched his window out. I go to jail for that at my home. Okay. Then so I come to court, and the prosecutors, Judge Rand Washington is the eyewitness. This same prosecutor, while he's in court on camera yesterday, sir, while he's on court on camera, just please hear me, said Mr. Buckner is threatening my witnesses in court. This is what this same prosecutor said. Judge Rand Washington said, no, he's not. Mr. Buckner is talking to me, and he's not threatening. See, they had already had it out.
Hold, stop. There was a video requested. Does the video show anything?
Yeah, I haven't had a chance to review it. I just got it this morning. But we were informed immediately after the threat occurred. I and she informed our advocate, and then informed us that it had happened. And then she did a police report, and then we authorized the charges.
Your Honor, may I?
Hey, just a second, Mr. Johnson. Has the complaint's been authorized? Has it been sworn to?
I don't think so yet. It was just authorized this morning at 8 a.m.
All right. Yes, Mr. Johnson, go ahead, sir.
Your Honor, this was not my case. This was the public defender's office's case. My case was dismissed prior to this case on Tuesday. I have no knowledge of this. I have no discovery on this. So I can't effectively address this and make sure my client gets his due process rights in terms of a bond revocation hearing. I understand that this may have just happened Tuesday and all the police reports and video camera have not been gathered. But I do think it is unfair to address this right now. Mr. Buckner has always showed up to court. He's always showed up to court timely. I think it's best for the attorney who was present at that hearing to handle this bond violation, especially if that case is still ongoing. I just can't effectively represent Mr. Buckner on a bond violation that I did not know was going to occur this morning right now, Your Honor.
Yeah. Mr. Brown, were you there on that?
I was not, Mr. Michael. First of all, one round that. I was not there, remember Michael Daddy was. I'm not sure it's this being handled as a bond violation.
Well, they're asking for revocation of this bond because of new charges, I presume, and the nature of those new charges. So that's what they're asking for. I think a couple of things. And I don't know what, there was a request made for video from this courtroom of that day. We got time narrowed down. You need to take your hands out of your pockets. And the request was made. I checked with Judge Washington because she was the judge presiding as to whether or not she had any objection to that. She did not. That was, I think, Byrne provided to the people in this case. They have not had an opportunity to review it.
So as it stands now, these allegations that they have violated nothing's charged.
Well, no, it's basically charged. It's authorized at this point. It's just that it hasn't come through the system yet. Okay, so here's what I'm going to suggest, and it may not like it, but I think maybe this is the way to do it. The video, somebody from your office, Mr. Brown, was handling his exam, correct? Okay.
We just talked about witness.
He didn't see anything. So what I would do, and I get Mr. Johnson's point, he's trying to do that. What I'm going to do is temporarily take the defendant into custody. I want that video provided to Mr. Buckner. Mr. Buckner. I don't know what's on the video. I did not view it myself. And then have counsel look at the video, and then I will myself look at it when I get a break to be able to do so, and then make a determination if based upon that, his bond in this case should be revoked. I think that's probably the fairest way that I can potentially do. Yes, sir.
Sir, I appreciate you first and foremost for this opportunity. Can I say just to the court that upon looking at the video, the prosecutor said that I want the whole court to hear it. I physically said that I was going to threaten and get this woman.
Sir, first of all, I don't want you saying anything about what's going to be that new case coming up. I don't want you saying anything. I'm not going to hear it because you're going to end up hurting yourself. What I have said is you will be going into custody. We will then, and I'm not saying even at this point, I'm going to keep you in custody. A video was requested. I'm going to give, the prosecutor's got to look at it. I'm going to give counsel that was handling it at that time an opportunity to look at it also. Mr. Brown has already indicated they spoke with your attorney at that hearing and he did not witness anything. And I don't know because I was not the judge presiding. So this is the best that I can do to try to figure it out, at least preliminarily.
Mr. Judge Simpson, I'm a very honorable person. I'm asking in all due respect. I'm not a flight risk, sir.
Sir, I'm not saying that you are.
My dog's in the car. Is there any way that I can call my brother so he can come?
Sir, I'm going to expedite it as best I can to make sure that I can look at it, get you recalled back up, and tell you what I'm going to do. But I think everybody has to look at it. Mr. Johnson's not here, so he can't himself look at it, but it affects his case. But the people that can look at it can do that and maybe get in touch with Mr. Johnson. I don't know, but I'm just saying that's the way I'm going to handle it at this juncture. All right?
You don't represent me. Okay. So the guy that represents me is Mr. Gotti. Mr. Gotti is the key factor that you being here.
Okay, look, Mr. Buckner, they'll be able to talk to you back there. But I'll pass the matter. Sir, you need to just quiet down, please.
The court is aware of all the sentence doing the video.
All right. And Mr. Brown, Mr. Brown's going away. Okay, thank you. Got it. We're all set. All right, court does call the cases of the people versus Tamika Slip. All 5 cases. Hello, Miss Slip. How are you?
I'm good. How are you?
I'm great. Thank you.
You're still smiling, I see.
Yes, ma'am, I am.
And I like your pretty shirt.
Thank you.
You're very welcome.
All right, thank you. Please.
Thank you. I'm not done that I can marry you. I just gotta say you got beautiful smiles.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Schlip. Ms. Schlip, will you please say your name for the record? Hi, how are you?
I'm good. How are you?
Not too bad. Can you say your name for the record?
Tamika Dwight.
Your Honor, may we approach briefly?
Please.
What the fuck? I'm back.
Yep, you are back. So am I.
Here you go.
Okay?
Okay, I'm sorry. I'm
All
sorry,
right.
Mrs. Simpson.
No, you're okay. All right,
I
so,
just get really hyper because I have autism and get really hyper when you see people I know.
okay. All right,
It makes
so
me
here's
feel
what
good.
I do. Go ahead.
Yeah, I said that. You make me feel good because you always smile at me.
Well,
And I told you over and over again, so you have a very beautiful smile.
yes, you did. Okay, so here's what we're gonna do. Miss Slap,
Yeah.
there's an agreement in your case that you're gonna plead no contest to a disorderly person. That will be in the case ending in 727. Upon your successful no contest plea to that charge, count 1 in that case would be dismissed and all of the other 4 cases would be dismissed.
I don't understand what you mean.
Ms. Schlip,
Yeah.
do you recall meeting with Ms. Cannon earlier this week?
Oh, you're
Hi,
involved.
Stephanie.
This is what Ms. Cannon discussed with you in entering a no contest plea to the 1 count of disorderly. We're gonna ask the judge for immediate sentencing, and then all of your cases here will be closed out.
Okay.
Is that what you'd like to do today?
Yeah, I want to plead no contest, and I want to be done coming to court.
Okay. All right, Ms. Schlip, the court and or myself are gonna ask you some questions.
Okay, if I can remember.
Well, yeah, we'll ask you them and just, most of them are yes or no answers, okay?
Okay.
Okay. So first thing I need you to do, Ms. Slip, is I need you to raise your right hand.
This one?
Nope,
That
other
one's
one.
right.
There you go. And do you solemnly swear or affirm that the testimony that you'll give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
All right, state your name again.
Tamika Joy Ship.
Okay. It's the court's understanding that you're going to plead no contest to the charge of disorderly person. That's a misdemeanor punishable. Okay, that's a misdemeanor punishable by up to 90 days and a $500 fine plus court cost. Do you understand that?
Yes, sir.
Okay. Do you understand what a no contest plea is?
I think Stephanie told me I'm not pleading innocent, but I'm not pleading guilty either.
That's true. What you're doing is you're not contesting the fact that you may be guilty of disorderly person.
Okay.
Okay.
I'm sorry.
What I will do is I will read over the police report and I'll accept those facts as true to determine whether or not you committed that offense, okay?
Okay.
Okay, the other thing that you need to understand is that for purposes of sentencing, the court would be treating you the same as though you had pled guilty.
Okay, that's fine.
Okay, okay.
I'm sorry.
So, no, that's good. So understanding all of that, how do you plead to that charge?
Yes, I plead no contest.
Now you understand that by pleading no contest, you're not going to have any trial at all. You understand that?
Yes, sir.
All right. You also understand that because of that, you're giving up certain rights. You're giving up your right to call witness.
My Manda rights. My Manda rights, right? My Manda rights.
Your Miranda rights?
No, Miss.
Yeah, that was
your trial rights.
No, you're giving up your trial rights. I'm going to tell you what those are, okay?
Okay.
All right. So you're giving up your right to call witnesses or have this court force the witnesses to appear at court to testify against you. You understand that?
Yes, sir.
You're also giving up your right to see, hear, and question all witnesses against you at trial. You understand that?
Yes, sir.
All right. You also understand that you're giving up your right to be a witness for yourself or to remain silent and not have that silence used against you.
Yes, Mr. Simpson.
And you're also giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that?
Yes, Mr. Simpson.
Okay. You're also giving up your right to an automatic appeal, and that's basically giving up your right to appeal of right. You'd have to ask permission to appeal this case or the sentence. You understand that?
No, because I don't know what you mean by appeal. Like appeal on an apple?
No. If you don't like the fact that you are having a conviction in this case or the sentence that I'm going to impose, if you don't like it, you'd have to ask permission of the higher court to hear any complaint you have.
Okay, I understand now, hon.
You
Sorry.
understand that?
Yes,
Okay,
Mr. Simpson.
Okay, it's true you're not on probation and you're not on parole, right?
That's right, sir.
Okay. Has anybody promised you?
I'm not on parole, but I hope I get my parole soon.
Okay.
Home.
Okay, me too. All right. Nobody's promised you anything other than what we've said here today, that you would plead to this one charge and then everything else would be dismissed. Nobody promised you anything else, did they?
No.
Okay. Has anybody threatened you or forced you in any way to enter this plea?
No,
You're doing this voluntarily and of your own free will, correct?
yes, sir, and of
All
God
right.
will.
Okay.
And God
And
will.
I
So
have
we do everything
been
through
provided,
God.
I've been provided and have reviewed Michigan Department of State Police report for their case number 624-24. Any objection to the court having reviewed that report?
No objection, Your Honor.
No objection.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Your Honor, defense is satisfied.
We are satisfied.
Court will accept the defendant's plea of no contest to count 2 in case ending in 727. Count 1 in that case is dismissed, as well as the cases ending in 1449, 1706, 1823, and 654. Those are dismissed as part of this agreement. All right. Okay. Anything you want to say before I impose sentence?
Me?
Your Honor,
Sure. Well, yeah, yes, I have to give you that right. You have, but go ahead.
I just want to
Please.
say that I hope you guys do.
Hey.
God bless us.
Okay, Ms. Slip, hold on a moment. I'm going to let your attorney talk to me first, okay?
Okay.
All right, please.
Your Honor, we're asking the court to consider a credit for time served sentence on this, waive any fines and costs the court can, considering Ms. Schlipp's status in the Michigan Department of Corrections. Your Honor, she has been in custody for roughly the last 7 years on an 18-month sentence out of Jackson County. So we're asking, based on those circumstances, the court impose a time served sentence. Once this files out. Thank you.
Ms. Slip? Anything you want to tell me before I impose sentence?
I just want to say God bless you, Mr. Simpson. And I want to also tell you, Mr. Simpson, I prayed for you.
Ms. Slip, thank you for that. I do
You're
appreciate
very,
it.
very welcome. I pray for you because I know your job can't be all that. Like, it probably gets real frustrating. So I ask God to give you strength and wisdom to keep going.
Ms. Slip, it's a sentence of the court. Fines and costs of $125, sentenced to 90 days incarceration, credit for 90 days served. And Ms. Slip, you would appear here every couple of weeks. This is it, or the end of it. So I'll just let you know I'm going to miss you.
I'm gonna miss you too, Mr. Simpson. I'm definitely gonna miss your beautiful smile.
Oh, yes. Thank you, Ms. Slip. You take care of yourself, okay?
Okay, I will, Mr.
Yes,
Simpson. Just
hold
God
on, Ms.
bless
Slip.
you.
There's, okay, thank you.
I just want to put on the record, just that as recently as February 27th, this court signed an order finding the case competent.
Yes.
And there's no reason that we believe that status has changed and yet.
All right. Very good.
Thank you.
Thank you. All right. Take care, Ms. Slip.
Take care, Mr. Simpson. Bye. Have a good day.
Bye-bye. Court does call the case of the people versus Lawrence Buckner.
Joseph McMillan, people, Your Honor.
All right. Mr. Johnson, you're muted. Go ahead.
May it please the court, Kareem Johnson, appearing on behalf of Mr. Buckner.
All right.
What about that?
Yes, I'm going to do the arraignment. And just to bring you up to date, Mr. Johnson, the new case that we were talking about has actually been, I now have the file and I'm going to conduct the arraignment on that charge. So, all right. I don't know if you were informed of that. All right. Your name, sir?
Sir, my name is Lawrence Edward Buckner Jr.
All right. You are before the court on a felony complaint, a one-count felony complaint that alleges that on or about April 1st, 2025, at the location of 4133 Washington Avenue, that being the 14A District Court, that you did influence or attempt to influence the testimony at an official proceeding by threatening to kill or injure a person. It's commonly known as witness intimidation, committing a crime threatening to kill or injure. Not asking you, sir, whether or not you believe you did that offense. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony. It is punishable by up to 15 years incarceration and or a $25,000 fine plus court costs. Do you understand that? You understand that, sir? And you understand also, sir, that a consecutive sentence may be imposed for any other conviction. Do you understand that? Mr. Buckner, you can sit down while we go through this.
All right, so I didn't know. I'm sorry.
Did you understand that, sir? That a consecutive sentence may be imposed for any other conviction.
Sir, forgive me for my emotional upbringing. I don't know what to say right now, sir, and I truly apologize to the court. I don't know what to say yet.
Well, I just need to make sure that you understand and can answer the questions that I'm asking. I need to make sure of two things primarily. First of all, that you understand what you charged with. You told me that you do understand that. The other thing that I need for you to understand is what the maximum penalties are. Miss
Cameras. So there's no video.
You may want to mute that.
So this is my freedom just snatched me, and I was understanding this son, the white came with that picture. That was charging me. See, I told you I got shot in the head, so you're not hearing the wrong thing. Okay? And you said it wrong. Video, but now you tell me what video. That's what I'm not understanding, because the whole basis of my freedom today was Judge Simpson in the video, and that's why I need help. Oh, what charge is this? This is the charge of having April 4th Judge Washington court? Okay. Potential. I understand the potential. I just, from the time, I apologize for the sentence. I'm a little slow right now, so I apologize to the court ahead of time. Y'all be further ahead of me. Second to original charge. Second to original charge. Ms. Johnson, Ms. Washington, want to find out. Yeah. I understand, Judge. I'm sorry, I don't.
Okay, so you understand then the maximum penalties on that charge?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney on this? It's a public defender case.
Right.
As to the formal reading, you waive any further formal reading of the complaint, stand in. All right. All right. defendant pleading not guilty, demanding a probable cause hearing. Court will enter that plea. Set a probable cause hearing, and Mr. Johnson, before I set that date, were you asking for an adjournment of the other case? You were asking for that to be set for exam, were you not?
I was, Your Honor, but based on these new developments, I think.
Jail. I'm not trying to stay in jail, Mr. Johnson. Like, please help me. I'm not trying to stay in jail.
I will.
Like, I don't want you to tell the judge to adjourn something. And then I need to be heard on it. And I could find out I did nothing wrong. I need help. And helping me is not leaving me inside Washington County Jail or trying to put me on some type of crazy bond. Like, I need help.
Okay, Mr. Buckner, Your Honor, based on my client's representations, I still ask that the court set this matter for exam. As I indicated this morning on my case, Mr. Buckner has, I believe, 2 or 3 witnesses that we would like to try and call at exam. I need some time to subpoena those witnesses. So I was asking the court for an extra week.
So if we were setting the 15th, you would be looking at, say, the 22nd, you're saying?
Yes, sir, Your Honor.
All right. Any objection to that from the people on case ending in 1120?
No, you're saying that the 22nd is not.
All right. So in that matter, preliminary examination will be in person. It would be set for April 22nd, 2025, 9 a.m. That is before Judge. Well, all right. Right, but I think that will be before Judge Washington. All right, and on that case, his bond would continue. All right. So on the other matter, I'll set preliminary examination and I hear what the defendant is saying. What date? PCC. I set it for the 17th. Card. Okay, then I'll set it for the 10th. I'll just set it out a week. April 10th, 2025, 9 a.m. on that matter. As to bond in this case.
Allegation here is that my client allegedly had some outbursts and witness. I had a chance to look at what was available on the equipment that was done. Looking at we can see and strong as the outcome. Charge for destruction is witness intimidation. That means that he was trying to prevent this witness from coming to court and testifying, trying to change what this witness has. All of it goes to whether that witness would be able to appear in future court. Taking the best heard of the prosecution. Said you've been lying on me. Ms. Evans, my client is not saying he said that, but what the prosecution says that you've been lying. She showed you or something to that effect. She shoots you to this. Yeah. Notion is for threatening intimidation is that he has to be doing something to prevent this witness saying, don't come to court, trying to stop this witness. I think even if we hold her this allegation based on her, I don't think the prosecution should be able to make out a case that his intent was to try to prevent this witness from showing up, coming to court, intimidating this witness from saying, testifying truthfully. That's necessary. Because I do not believe that he will be successful in the conviction, I'm asking that the court set for my client a personal recognizance bond. And here's the reasons why a personal recognizance bond. You have the ability to have no contact. It has a home in Ypsilanti, 1680 box. It's not having anything to do with money witness lives is separate. He's self-employed, he raises his dogs to sustain himself. He suffers from numerous bad living that was already being raised and he's been shot a lot of times. So he's got health problems that arise from that. Finally, he lives, he's autistic, and he's has to take care of. He also has a brother who can help him make sure that he returns to all future workmates. It's a responsible individual. They should. I think the charge here is a strong charge. I think it's a charge that even taken in light, most favorable to the prosecution, they will be able to prove that he probably caused that.
Thank you. Response.
Thank you, Your Honor. In this case, as in many things, context is key. This exam was first this Tuesday. At that time, the victim testified and examined. The defendant pointed a gun and racked it at her while she was working as a security guard. It was after this that the defendant asked to go to a bathroom. While walking out, threatened her in the gallery. She immediately reported this to the victim advocate and his assistant prosecuting attorney. Specifically, this defendant said, "You're lying, a lying fucking bitch, I'm going to get you." This is right after she had testified being threatened with a firearm by this defendant. Based upon this defendant's conduct, Your Honor, people believe that a $100,000 bond, no 10%, is appropriate in this case. This was very clearly an attempt by this defendant to intimidate this witness with regards to the case at District Court at exam. The condition of the bond in that case, case number 5-121, I'm sorry, I may have misread that case number, was that he had no contact with the victim, and here he is in court threatening this victim. This is not taking place in a vacuum. This defendant has a pending misdemeanor domestic violence case, the FA case that was the subject of the exam involving firearm, and malicious destruction of property felony case. Based upon this conduct, based upon his extensive criminal history, they frankly have extreme concerns for public safety and victim safety. We're asking that as a condition of the bond in this case, that he have no contact with the victim in Hudson, have a no-go order as for residential place of employment. And frankly, Your Honor, it is this defendant's conduct which has brought us to this point. And the fact that this threat was uttered during a court proceeding immediately after the testimony of the victim is greatly concerning to people. And to our mind, points to a need to set a significant bond to secure the safety of the public and of the state.
So I'm response, Your Honor.
Yes, sir.
Obviously, very clearly, something different in the prosecution that Flynn described it as an angry outburst. It doesn't rise to showing any intent to keep anyone doing anything, except that angry outburst. They went ahead and tried to charge a witness intimidation. It's not that the person already testified, said she was lying, was angry, it was an angry outburst. But we're not going to try to hear it, show the prosecution is that the court takes into consideration the likelihood of conviction. The likelihood of conviction is, as the prosecution says very clearly, I think that's the case at all. And what you have is not angry outburst that's being spun, something based on what they saw in context, an unproven charge.
But if it were directed at the victim in that case, that irrespective of what's being said, that would be improper context, you agree?
That's right. Making a line with a separate case, and that's exactly what's going on. They can certainly say you shouldn't have said anything, you shouldn't have an angry outburst. That's a bond violation. That's exactly that. In the context of whether or not they should be charging this case, and with this their discretion, they can decide in the context of whether or not they would likely to get a conviction based on that flimsy information they have there. That's not right. So yes, maybe they can say it's a bond violation. They should be actually bringing a bond violation rather than charging an entire case. They can't complain to me and say, "Oh, well, we've got a new case based on that."
So there seems to be a misperception because the victim testified at exam that somehow this conduct was not supposed to be the victim. The victim's testimony would be needed at trial as well. And to make this statement, not only that accused her of lying, that he was going to get her. But the same victim has seen this defendant firearm at her and rack the weapons. Clearly, the intent here was to intimidate the witness in question. So based upon this defendant's conduct, I need a $100,000 bond with no 10% is an appropriate remedy. As an additional condition, Your Honor, should this defendant be able to go gas or GPS tether, it will go conditions as to placement of employment residence to the victim. But very clearly, this defendant
I don't know that I have a name for the.
The name of the victim, Your Honor, is Amy Hudson. That's A-M-E. The first name, Hudson.
Say again.
A-M-E-E.
Okay.
Last name Hudson, H-U-D-S-O-N.
Anything else, Mr.
Works is it's on a motion, let respond, response, and it's supposed to stop.
Well, I can actually run my courtroom any way I want, but that's okay. Thank you for the suggestion. I'm gonna order standard conditions, including no assaultive behavior or any possession of any weapons or anything fashioned to be a weapon. There's to be no possession of any alcohol, recreational marijuana, or any illegal drug. I will order no contact with Amy Hudson. You're not to go to either direct or indirect or through third parties. I will also indicate that there's be no mention of Amy Hudson on any social media or any use of any type of social media. You're also not to go to that person's residence or employment or place of employment, I should say. What is concerning in this case is that if what is said, and I disagree with the defense, that there has to be something where they did that there. If said, if what is indicated was said, which oddly is consistent with, in some respects, with the underlying offense and what is said, which makes it even, I will have to say, more frightening if it was said. And that it is said during, even at a recess, but during a court proceeding where the defendant knows he is not to have any contact with that particular individual, is highly problematic and something this court cannot tolerate, should it be. That type of individual, in this court's mind, does pose a significant threat to the public in regard to his behavior. I would also indicate that I don't necessarily believe that the defendant is a flight risk, certainly, but I do believe that given everything that the court has heard, he is a significant danger, if not to the public in general, to this one individual. He may be a particular danger. The court is going to set the defendant's monetary amount of his bond at $75,000 cash sure. If the defendant is released, he is to be placed on the GPS home confinement tether. The court may allow, upon petition, his ability to go to work once that's established, but $75,000 on that case. Thank you.
This possibly from the judge last year. It's same stuff that they charge me for right now. Same stuff that they charge me for right now.
A prosecutor told Judge Washington that I was disrespecting and threatening her client inside the jail, on inside the courtroom. Judge Washington looked right at her and said, "No, you're not." He looked right at me. So I asked you to talk. Judge Washington could have helped me on this. Because they got me charged on. They got me charged, Judge. So this thing, right, for me to make one statement, Judge Simpson, I'm charged with making a crime in the courtroom, right, sir?
Well, you're charged with intimidating witness that may have taken place in the courtroom.
Okay, and sir, this is the time that I got arrested and you sent me back here, the thing that I was trying to work on you was, I mean, the community of people that was helping me, sir, and I know everything I'm saying, but you already made a decision, is that the video inside Judge Washington's courtroom, Wayne Washington courtroom, was the video that would have proved my innocence. The prosecutor told Judge Washington that I was threatening Amy Hudson while she was giving her testimony on the stand. Amy Hudson was on the stand. Wayne Washington stopped the court immediately and said, no, he's not. He ain't looked at her, he ain't said to her. He's mumbling things to me, trying to get my attention. This is on camera in Wayne Washington court. So now, how do I help myself, Judge Simpson?
Your attorney will be able to get a video of that proceeding. All right, Mr. Buckner, thank you.
Hey, Mr. Brown.
Yes.
Thank you.
No, I don't, but the conditions. Court does call the case of the People State of Michigan versus Christopher Day.
Good afternoon, Your Honor. This is Attorney General Michael Doby for the people. Good afternoon, Your Honor. Douglas Such, I'm happy to say his present play. Right.
All right, I had the testimony, and this is a continuation of the preliminary examination. The testimony was heard in the case. I don't know that I took the people's motion to bind over. So I don't know if you have a motion.
Yes, Your Honor. Relying on the argument made the last time we were here, I do ask the court to bind over.
Is there any additional argument for the court gives its decision?
No additional argument.
All right. In this case, and quite frankly, when one views the video, the factual circumstances are rather clear and somewhat straightforward. However, the defense raised two particular issues as it regarded the charges in this case. Specifically, one issue as to whether or not the use of the spray or the mace would constitute a dangerous weapon under the felonious assault statute is one issue. And then the other issue is whether there was corrupt behavior in that regard, and that the misuse of office, quite frankly, or the offense itself can't be because of a policy violation. I'll clarify that more in a moment. As to the issue of whether or not the mace constitutes a dangerous weapon for the purposes of felonious assault, the court will answer that two ways. The court, first of all, believes that the manner in which it was used in this case, where the individual was handcuffed in the back of a police vehicle in effectively what is considered a cage where they cannot go, and that it was used, and that the individual, Cameron Hissong, frankly, at that moment, posed no threat whatsoever to the officer, that the manner in which it was used, this court does believe the people have sustained a burden of showing that it is a weapon. I would further note that when one looks at the jury instructions regarding felonious assault, that as to whether or not something would constitute a dangerous weapon also can become in the manner in which it's used, and what may be an ordinary, or at least an object that may not in and of itself be designed to be a dangerous weapon, that the totality of the circumstances and the facts and circumstances as to whether or not the people would be able to show that would have to be assessed by a fact finder as to whether or not its use constituted a dangerous weapon. So specifically in answer to that, this court does believe that people have shown that it's a dangerous weapon. However, even to the extent that the people did not, that question is not directly a legal question, but would be a question which would properly have to be determined by a fact finder as to whether or not, under the circumstances of this case, it was used as a dangerous weapon. So for those reasons, and all the other elements of that offense being shown, the court does believe that the people have sustained their burden as to count one and would bind the defendant over on that charge. As to the issue of the common law offenses, did commit an indictable offense at common law, namely the misconduct in office. The defense correctly points out, and I went through the cases that were given to the court, and I'm going to list them. They were provided in chambers conference, and the court reviewed them. What's clear is that the defendant did violate the policy, but the policy itself is not the basis or cannot be the basis for the misconduct in office, but certainly can be used as to whether or not there was corrupt intent in the commission of the offense. So in that respect, the court, and in viewing it that way, the misconduct in and of itself is not the basis for the charge, but can be, and this court does believe, could be determined by the fact finder as showing the corrupt nature of the defendant's action. And so for those reasons, the court does believe that the people also have sustained their burden and would bind the defendant over to stand trial on the offense of misconduct in office. Therefore, the defendant is bound over stand trial on both counts. All right.
Your Honor, just one item to make the record clear. The
Yes.
court had accepted those policies provisionally.
Yes.
Awaiting its ruling.
Correct. Yes, the court will accept those policies and those exhibits are admitted.
Thank you.
All right. And
Is it for a separate court?
yes, we will, but we go through the arraignment, and so you have been presented the information in this case and waive its reading at this time, so.
Yeah, we'll wait for it.
All right, defendant having waived for reading, standing mute, court will enter a not guilty plea as to both counts. Pre-trial in this matter will be set for
May 22nd at 1:30 before Judge Slay.
May 22nd, 2025, 1:30 before Judge Slay. Bond in this case will continue.
Thank you.
All right.
May I approach the sign information?
Yes, sir. It is. That's what I thought. All right. Thank you.
Rachel Mayrand. Rachel Nicole Mayrand. 232640488. Where is she? I don't see her here. It says time to pay, please, on the file.
Yeah, I wonder if she went in the hall by mistake.
I just love that. So everybody going to opening day tomorrow can go out in the concourse instead of going into the game. You know what I mean? Buy a hot dog across the street and walk around.
Your name?
Rachel Marion,
You gotta be kidding.
how are you?
You're coming in a year after the fact and asking for time to
I
pay.
just got the notice on the 25th of March. I said the same thing. I said, where is this coming from? I did my workforce days, everything.
Hang on a sec. You didn't pay your fines.
I wasn't even aware.
Ma'am,
Yes, sir. I am on it now. I apologize.
what do you think I'm thinking?
I thought the same thing.
What do you mean you thought the same thing?
Well, when I finally got a notice a year and a half later.
Ms. May Rand,
Yes, sir.
who's your probation officer?
Jessica O'Donnell.
Call in Jessica. I want to give you a little analysis here, okay?
Okay.
On February 1 of 24, after you were found guilty at a bench trial, I sentenced you. I ordered you to pay $765, 4 days court work program, gave you credit for one, or you had to serve 90 days if you didn't do the court work or didn't make the payments. Your payments were to be paid at the rate of $25 a week, beginning February 29 of 2024. This is April of 25. Last I looked at a calendar.
Yes.
That means you haven't done anything in over 13 months. I'm gonna go back and check out how many times you paid. It looks like on April 3 of 25, today you came in with $50.
Yes. And I have more, yes.
And now you want to act like this is some surprise out of the sky that you didn't know you owed the court money. You didn't know anything.
Yes, I didn't know.
You
I
did know or
completely-
did not know?
I mean, I know how the court works.
I didn't ask you that. You made it sound like you didn't think you owed and you thought you were done. If I misunderstood, listen, don't interrupt me. If I'm misinterpreting what you said, please, when I'm done talking here, Judge, you misunderstood me.
Yes, sir.
Okay?
Yes, sir.
Fair enough?
Yes.
Now you're going to listen.
Yes.
You come in here and you act like you thought all this was behind you. Ms. Mayrand, I don't know what's going on with you. I really don't. But this was as predictable as the fact that it's going to be less than 138 degrees out today. This was so predictable. I mean, I'd have bet my house against this coffee mug that you were going to do this. I don't know why. I don't know why. I really don't. But I don't like hearing these things. Your name?
Just hold on, I'll have information on.
So I'm a little curious. On April 25th of 24, she was supposed to be here for a show cause. I don't even know why I called you in. I have the answer.
Yeah, I was gonna say, this was a non-probation case, court work program only, and then money. Rachel was in rehab for quite a while during this time frame. I did have proof that she was in rehab. She was in Naomi's Nest for quite a while. Once she was released from Naomi's Nest, she did contact me right away. She contacted me while she was in there as well. She completed all her days on court work program. It's just the money left that we're working with.
Yeah, but I issued a warrant for her arrest on April 25 of 24 for failure to appear for a show cause that alleged that she didn't appear for her court work program days on March the 23rd and April the 13th of 24. So how'd she, we had
I'm assuming she came back into.
I don't want you to make
after
any
that.
assumptions though, because I don't know that that's the case. I never saw anything with her. It looks like is that right, Lisa, that on April, what is going on here? You then came back in front of me on April 30, pled guilty. I said, pay additional costs of $700, $75. 2 additional days court work and pay $35 in court work program fees. 1 day court work because I gave you credit for 1 served. I'm just curious as to why we didn't show cause her after she blew that off.
Again, she was in custody, she was in jail for quite a long term, and then she was in rehab after that as
Not
well.
on this case, she wasn't. What case were you in custody on?
For this one, and I was in front of you, you said what day? The 30th of April? I was in custody until September.
Of 24?
Yes.
She had
And
pending
then-
felony charges, Your Honor, at that point.
Shocking.
From,
I'm so shocked. I'm just a little agitated that here she comes in a year later and now she wants time to pay. It'd be like me blowing off my mortgage company for a year and then going in and saying, you know what, give me an extension. I'll pay you. Ms. Mayran?
yes, sir.
I don't know about you. I mean, you're hell-bent on destroying your life. I can tell you that. I felt like that before. And I know I would have told you if you didn't have the money to come and talk to me. And if you want to dispute that, I will go ahead and go back and I'll instruct her to go listen to the recording right now. And I'll make a determination as to whether or not I adequately explained that. I know I would have told you because I tell everybody. You never asked me for extensions. Now you come in after we're almost done with probation. There was no probation. Where are you working?
At Koi and at Revive at the LA Fitness.
What's Koi?
Koi is the new hibachi restaurant right there at West Road and Grange.
What do you do there?
I'm a server, I'm training to be a server.
Are you off the drugs?
Yes,
You are.
yes,
So if I sent you for a drug test right now, you'd be negative.
absolutely.
I can't believe you didn't come and talk to me. You're going to set up a payment plan now and you're going to, but I don't want to hear any more about you thought this all went away. How much can you pay weekly? Where are you living? You living at home with your mother?
Yes, sir.
Okay, so you don't have a lot of bills, right?
No, I do not.
Okay. How much can you pay weekly?
50,
Okay.
25, 50 weekly.
You tell me when you can start. Today's April 3rd. It's a Thursday. Next Friday would be the 11th. You want to start next Friday, the 11th?
We start the 15th.
I'll make it the 18th.
Thank you.
If you don't have the money and you pull this nonsense again, I'm going to lock you up.
Yes, sir.
If you don't have the money and you need more time, you can extend a courtesy to me. Like I'm just bending over backwards for you right now. You will come into the courthouse on or before the due date 8:30, or you will call the courthouse on or before the due date. And I will go on Zoom with you at 8:30 and I will give you an extension. Do we understand one another?
The due date of, so I understand. When's the due date? 100%, just so I understand.
April 18th, starting April 18th.
Okay.
You are going to pay.
April 18th is a holiday, just so you know.
All right, so you can wait till the 21st on that first payment, but every Friday, I'll tell you what, I'll just make it April 21st.
Okay.
That's a Monday. Every Monday, starting April 21, you come in here with $50. You don't have the money, you got to come talk to me. You don't do either one of those. I'm glad you're clean if you're clean. I really am. You got to stay away from that. What was it again? Meth?
Yeah, it was all a bunch of,
Yeah, I mean, you can't do that. That's bad. Bad, bad, bad. Bad news bears.
very,
You look a lot better.
thank you.
That's good. Good luck.
Thank you.
Take care, Ms. Mayran. Don't miss again. And don't be throwing my name out there. You said you know me. Some police officer told me you said, I know Judge McNally. Judge McNally likes me. You did say that to somebody.
If I did, it was the drugs. I apologize.
I don't like people throwing my name out there. Good luck.
Again, thank you.
Nestev, Ivan Angelo Destev.
Right to the podium.
25S118055. Wow. This is a big win. Your name?
My name is Ivan Nestev.
Wow. They didn't show up on this. The officer failed to appear. Case dismissed. It's an overweight of $2,364. You gonna remedy that? Be more careful next time? Good luck. Thank you. Have a good day.
Thank you.
Universal Intermodal Services. Oh boy, I can't let you appear here. 25S118071. Your name?
I'm actually yes, sir.
What's your name? Mohammed Changazi?
Yes, sir.
The company's supposed to be here, not you.
I'm a owner operator, the contract with the company. That's what I tried to explain the officer who stopped me.
Hey, they didn't show up either. You sent the notice to the company, right, Lisa?
Oh, yeah. We have
Yes, I'm talking to my judicial clerk.
Oh.
Yes.
You sent, all right, well, they didn't show up. So I'm gonna treat this as though nobody showed for the defendant, but nobody showed for the police. Case dismissed. Good luck.
Thank you, sir. You have a blessed day, sir.
You guys, boy, are you guys getting fortunate.
Thank you, sir.
Good luck. What do you guys have sitting in the front row?
I'm here for open talks.
For what?
Open in talks.
Did you check in with my court officer? You know where the file is, John?
I did not. What was the name again? Ricardo Zarate.
What?
Carate. You sure you checked in with me? I didn't have you marked off. I handed you my papers as soon as I walked in. Did I walk in the room? Did I throw that up there?
We'll just assume you dropped the ball, John.
Yeah.
I'm just kidding. Do we have the file down there?
It happens.
Do you have the file? Zarate? What city is that?
Flutter Rock. Oh, it's right here, Your Honor. That might have been
Are you with this gentleman?
Yes.
Yes. Sir, ma'am, what are you here on? I'm sorry?
She's here on a ticket for 10:30.
I know, but,
10:15.
okay. No worries.
Yeah.
I'll get you out of here real quick, Mr. Zarate. Give me that tail if I'll take care of that.
Thank you.
People, come on up here. People against Zarate. Ricardo Joseph Zarate, 25F2433593. Your name?
Ricardo Joseph Zarate.
You have open intoxicants in a motor vehicle charge, a misdemeanor punishable by up to 100 fines, 90 days jail, costs are all those 2 points. You have the right to a lawyer. If you want one, I'll give you one.
Yes, sir.
Do you want one?
Yes.
Okay, I'm gonna give you a lawyer. You'll go talk to the lawyer. The lawyer will talk to the prosecutor, see what we can work out, and we'll see you back here. So just go right out in the hallway. He'll take care of it, okay?
Thank you, Your Honor.
Thank you. Nothing else out there, Lisa? We ready on this, Clark? Henry Clark? Did you have a lawyer?
That's all on my room.
Jack Plea Ball, 25W8379578 and B. How you doing, Mr. Ball?
All right, how you doing, Mr. Daly?
Not too bad. Everything all right?
Huh?
Everything all right?
Not really. Been looking for a job for over the last 12 months and just see if you can't find one anywhere.
Just keep looking. You'll find something. Tell me your name.
Jack Lee Ball.
How much time do you need on these?
I don't know. Like I told you, I just been looking for the last 12 months, at least probably, I don't know, 6 months, I guess. I don't know, 90 days, something, I don't know.
Did you check like it, where have you applied?
Everywhere. I go to a lot of interviews and stuff, but I never get hired. And it's kind of hard to get by without any money.
I'll tell you what, I'll start you out with 90 days. If you need more time, just come talk to me. Just don't ignore me, okay?
All right. I mean, I'm trying. I just don't know what else to really do, you know?
I'm gonna give you until July the 7th to pay all these, both of these, okay?
All right.
If you need more time, come talk to me. Just don't ignore me. We'll work it out. What about McDonald's or one of those places? Did you try that?
I have not tried any place like that yet, but I'm about ready to, I guess.
It's better than not having any money, right?
Yeah, a job's better than no job, yeah. For
All
sure.
right, best of luck. July 7th. Need more time? No problem. Call the court. We'll go on Zoom or come in on or before the due date. I'll give you an extension. Good luck to you, Mr. Ball.
All right, thanks, Mr.
Wish you well.
Have a good day.
You too. Clerk, Henry Judy Clerk, 201 T6365007A, B, and C.
Good morning, Your Honor. Mike Hill Crawford representing Mr. Clark.
Clark, your name?
Henry Clark.
He stands mute, waives formal reading, right?
Yes, Your Honor.
Where has he been?
Your Honor, my client's, around this time, my client's wife had passed away and he just was in a dark place for a while, Your Honor. And he just didn't kind of deal with a lot of.
Mr. Clark, I'm sorry about your wife. I really am. Just can't wait 4 years, okay? I mean, this is 4 years. Come on. He's gonna plead to no ops and then he's gonna pay these others, right? Tell me he has money, because I'm not gonna be in the mood to hear somebody ask me for time to pay when they haven't been here in 4 years. I'm telling you.
Well, Your Honor, my client is here. He is going to be pleading to no ops, and he is going to be making some type of payment today. We'll be asking for a payment arrangement, Your Honor.
Well, he's gonna have to pay a substantial amount of these other two. I'm just telling you.
Okay.
You're gonna be able to do that, Mr. Clark?
Your Honor, my client only has $200 next month. He's on Social Security and he has been for some time. This is all he's got left.
$200 right now?
$200, all he's got to his name.
All right, if you plead to no ops, possible penalties are up to 100, fines, 90 days jail, costs are all those. Do you understand that, sir? I can't hear you.
Yes, I do.
Did you sign, read, and understand the advice of rights?
Yes, I did, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes.
To the charge, no valid ops on person, how do you plead? Okay, were you operating a motor vehicle on Van Horn?
Yes, sir.
Near Lathrop and Trenton, January 11 of 21?
Yes, I was, Your Honor.
Did you have a valid license on your person?
No, I didn't, Your Honor.
Are you on probation or parole?
No, I am not.
Anybody forced you to plead guilty?
No, Your Honor.
All right, I'll accept your plea to no ops. Dismiss the suspend pursuant to the agreement. Anything you want to say?
Again, Your Honor, my client's on a fixed income. He's coming out of a tough time in his life. He is trying to take care of his license. He's gone through an expungement program through the city. He thought that took care of the state of Michigan. He has since learned he has to go to each jurisdiction. He has started that process, Your Honor. This is his second stop. He's got one more to go. So he's on a fixed income. He's asking for a payment arrangement because he's got a variety of payment arrangements. So what he's submitting, Your Honor, is that he requests $200 today and $100 a month on the 5th, because that's when he gets his Social Security.
Why didn't you start this 4 years ago? Or 3 years ago?
Because when my wife passed, I was married for 45 years and I just didn't know which way to go.
On the insurance, you pay $200 today. I'll waive the balance. He still has to pay his clearance fee. Okay, so he's gonna have to pay his clearance fee too, but I'll reduce that substantially from 327 to 245. I'll reduce the expired plate way down from 222 to 125. Can you pay that one next month?
Can you pay 125 next month?
Yes, sir.
What day does he get his check?
The 5th.
You pay this by May the 10th, okay?
Yes, Your Honor.
And then I'll let you pay the no ops, which is 50 fines, 50 costs, 75 victims' rights, $50 justice assessment, 225 or 30 days. You pay $100 a month on that beginning June the 10th, okay?
Yes, Your Honor.
Fair enough?
Yes, ma'am.
If you don't have any money or can't pay it, no problem. Just call the court. We'll go on Zoom. I'll give you an extension, or you can walk in, Your Honor, before the due date. I'll give you an extension, okay?
Your Honor,
don't ignore me, all right?
Your Honor, thank you.
All right, best of luck. Thanks,
Thank you,
Mr.
Ron.
Crawford. is the officer here on that file yet?
He is not.
Ma'am, I give everybody 15 minutes, so if he's not here at 10:30, 1:30 or thereabouts, I'm coming out. It's scheduled for 10:15, right? Sure. People against Catherine Marie Laginus, 25S568200. Come on up to the podium here, ma'am. How are you?
I've had better days.
Your name?
Catherine Mattress.
Okay, well, oh shoot, there he is. Just kidding. It's close enough to 20 minutes. He didn't show up. It's 10:28. He's not out on Zoom, right, Lisa? It's Middlestat from Wayne County
No.
Sheriff.
No, not on Zoom.
Okay, congratulations. Case dismissed.
Thank you.
Slow down a little, please. Good
I
luck.
will.
Thank you.
Can I get a copy of this for my employers because I still have
Yeah,
to.
you ask for whatever you need down there.
Okay. Thank you.
Okay,
I
good luck.
appreciate it.
Right down to the end of the hall.
Yep.
Stay seated.
Court is back in session.
People against, let's take Zarate real quick. Ricardo Joseph Zarate, 25F243593.
Good morning, Judge. Mazen Gates up here on behalf of Mr. Zarate. Mr. Zarate, state your name for the record. Ricardo Joseph Zarate. For arraignment purposes, Judge will waive reading, stand you.
Is Roger still here?
He is.
Can we figure out? It's okay.
You don't need him?
No. So he's going to tender a plea to disorderly under 771.1.
Correct, Judge. He's got no priors.
I don't have a problem with it. I'm just, well, actually open intox.
It was open intox, but he was a passenger, Judge.
Yeah, I get it. I'm just trying to think if you can come up with something else. Usually I just fine them on these open intox. I mean, I guess I can do it. So you're gonna plead, you didn't sign an advice or rights form.
He does have one already, Judge. Yes, there should be one.
Can you give me that, please?
You'll have your copy.
Mr. Zarate, if you plead guilty to disorderly person, the possible penalties are up to 500 fines, 90 days jail, costs are all. I'll set terms and conditions. If you're compliant, you'll come back after a specified period of time and I'll dismiss. Do you understand that?
Yes, Your Honor.
Did you sign, read, and understand the advice or rights form here?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights. There will not be a trial. Do you understand that?
Yes, Your
To the
Honor.
charge disorderly conduct, how do you plead?
Guilty.
I'm just gonna take the factual basis on the underlying charge. Were you in a motor vehicle that was being operated on Gibraltar in Flat Rock, March 17 of 25 at 8:57 p.m.?
Yes, Your Honor.
You were a passenger?
Yes, Your
You had open intoxicants?
Yes, Your Honor.
What did you have?
I don't know what the exact, if it was a bottle, it said it was supposed to be a pina colada. He doesn't recall the specifics, Judge, but there
The
was.
seal was broken on that, correct?
Yes, Your Honor.
And you had possession of it?
Yes, Your Honor.
Are you on probation or parole right now?
No, Your Honor.
Anybody forced you to plead guilty?
No, Your Honor.
Need a probation order. I'll accept the plea. I'll dismiss the open intox. Is there anything you want to say?
Just that this is Mr. Zarate's first offense, Judge. He understands what he did was wrong. But to his credit, he wasn't the one driving. He knew better than that. We'd ask the court to take that into consideration, Judge, when sentencing.
Anything you'd like to say?
No, Your Honor.
1 month probation. I'll take it under 771.1. There are $20 in probation fees and $75 crimes victims rights fee, $50 justice assessment. That's $145, and I'm going to have you pay $50 in fines and $25 in costs. So that $125, $145, $195, $220 is your total. Pay that. Come back in a month. I still want you to appear here, okay? I hate to make you do that, but this is the way I do them on. So you have to come back here we'll take it under section 771.1. I'll give you a review date. You pay this fines, you stay out of trouble. I'll dismiss. So give me like, do we have a Flat Rock Day like on April the 30th as an example, or 1st?
They're here on May 1st.
May 1st, at what time you want to do this?
9
8:30?
o'clock.
9 o'clock.
Judge, Mr. Zarate will require, he's unemployed at the moment. He's gonna need a payment plan.
Listen, you're gonna have to find some money. I don't want to play with this case any longer. So take an open intax under that, okay? Why aren't you working? You graduate?
Graduated high school. I've been out of a job for a couple of months. I've been applying.
You're 24, gonna be 24?
I've been applying for a lot of jobs. No one's been responding.
All right, you're gonna have to pay this. You're gonna have to figure out a way to pay it by April the 29th. If you don't have the money, you come in here and talk to me. I'll have to extend probation, charge more fees. Okay, so just make sure you pay that money by the 29th. If you don't have the money, come talk to me, okay?
Yes, sir.
You understand?
Yes.
All right. You'll go down the hall, get your notice, and then I don't even think you'll need to meet with probation. Good luck.